Hello and welcome to our first panel webinar of the year, Critical Infrastructure, SOCI and CPS230, your paths to operational resilience. I'm your moderator, Michael Nelson, Senior Product Specialist for the LexisNexis Regulatory Compliance Solution. I'm joined by three experts on the topic of critical infrastructure, starting with Dudley Neller, partner at Gadens law firm and legal expert for the regulatory compliance, cybersecurity and privacy modules. Dudley, would you like to give us a quick introduction about yourself?
Sure, thanks very much, Michael. I'm happy to be here. I guess feeling a little bit overwhelmed because we've got such a huge reform agenda in 2023. There are so many changes afoot that I'm not sure any of us will be able to seriously keep on top of them. The SOCI Act in its many different forms seems to have reached a landing, which is great. That's just one of the things on the to-do list, and today we'll be talking about that. So looking forward to talking about that with the rest of the panel.
Brilliant, thank you, Dudley. We're also joined by Michael Howell, Research and Content Lead at Protecht. Michael, would you like to share a little bit about yourself for the waiting audience?
Thanks, Michael. So I have a background in risk and compliance roles, and as the title implies, do a lot of research leading into our enterprise risk management products at Protecht. Also contribute to a lot of the content, so blogs, ebooks, etc. at Protecht, and part of our training arm, looking at some of the digitising of our training. And yeah, definitely excited to be here today and talk about SOCI and all of its related aspects.
Fantastic, thank you, Michael. And finally, our third panelist is my esteemed colleague, Kieran Seed, Global Head of Content at LexisNexis Regulatory Compliance. Kieran, would you like to share something about you?
Thank you so much for the introduction, Michael. And can I just say what a privilege it is to be part of such an incredible panel of experts and thought leaders, and very much looking forward to the discussion today. As you've mentioned, I lead the content team for LexisNexis Regulatory Compliance, which helps you to forge a clear path to compliance with LexisNexis content know-how at our core. Our obligations registers, alerts, and information-driven solutions make compliance uncomplicated for GRC professionals across the globe. And I'm so lucky to work closely alongside Michael Nelson in his indefatigable efforts to support our customers to best implement our solution alongside esteemed partners like Protecht and with the support of prolific experts like Dudley.
Oh, thank you, Kieran. It's true. This is very much a dream team that we've assembled today. Now, just some quick housekeeping. So this is a recorded session and should run for around an hour. Should you have any questions on the topics that are discussed today, please email those to compliance@lexisnexis.co.nz and we'll endeavour to answer them for you. There'll also be a QR code that you can scan at the end of the session to get in touch. So today, we'll be covering the following topics: what critical infrastructure is in the practical sense, regulatory change and how the legal landscape's evolved, CPS 230 and operational resilience in the Australian context, and finally, how critical infrastructure rolls up to operational resilience and the ways to ensure that your risk program is fit for purpose. So let's dive into the first topic. In terms of the changes from Parliament in Australia, how do you see these changes affecting the way that organisations conduct themselves? And I'd like to start with Dudley. And the first thing I'd like to ask is, let's define terms. How would you define critical infrastructure?
It's a good question, Michael. And I think if you'd asked me that question maybe 12 or 18 months ago, I'd give you a very short answer. It would be the usual suspects: electricity, gas, ports and water. Now that you're asking me that question 18 months later, in the current day, we've seen the SOCI Act evolve over that period. So it's broadened out those original 4 sectors to 11 sectors. So there's almost not a sector that the new legislation doesn't cover. So I think it's a really good question. It's a really important point. And I think it's an important point from an audience perspective, that they don't just assume it's those usual suspects, and that they perhaps take the time as they get to know this legislation, how broad in fact that scope is, and where they perhaps sit on the where they sit in the scheme of things, because I think some people will be very surprised.
Yeah, and I think that's a good point, because it's one of those issues where people, if they consider themselves critical, they'll be looking for changes in relation to legislation that affects them. But if they're not even alive to the notion that criticality is now extended much more broadly than it has previously, they may not necessarily be across the fine detail that they're going to need to be. Michael, how would you define critical infrastructure?
Well, I think obviously there's the 11 sectors, as Dudley pointed out, and the 22 asset classes that are defined. But I think if you think about it more in the layman's terms, what are those assets or services that, if they're not delivered, are going to have an impact on our society, our customers, communities, that might cause, some level of harm if they're disrupted for a period of time. And I think going to Dudley's comment as well about how people might be wrapped up in that. It's not just the critical infrastructure providers themselves. It's who's in their network, is in their supply chain, who are their vendors and providers, because some of those are providing those services and need to be caught up in this as well.
Yeah, and I think that's another really good point. Criticality has ripples now, whereas as Dudley made the point that it was your ports and your powers and so on, it's now expanded beyond that, and there will be, I think, potentially significant changes in the way that organizations conduct themselves, even beyond those kind of 11 core areas. Which leads us to Kieran. So if we've now got hopefully a clearer understanding of what critical infrastructure is, talk us through the effect of recent reforms in that particular area and how criticality, when it comes to infrastructure, has evolved.
Thanks, Michael. And I think it's a really good point to start to really tie this into what is specifically being required of entities across such a wide area. And certainly what we see in the legislative evolution, we're about 5 years on now from when that SOCI legislation first came in, and seeing how it's evolved in that time with that recognition that what is critical to the operation of society can't be limited to utilities and ports. And we've seen that in how the asset classes have broadened, and what is expected of those kinds of responsible entities has broadened as well. So when we look at the changes which took effect towards the end of 2021, we see these new set of obligations on that broader class of specific entities, such as financial services and financial markets, healthcare, universities, food and grocery, transport operators. It really is quite a laundry list now, and it's quite a far cry from that narrow position of 5 years ago. And then in March of last year, we've got those additional amendments which create new obligations around creating and maintaining a risk management program, and really seeing that increased emphasis on risk and risk management across the regulatory process. And that is really where we're seeing that evolution in terms of how regulators are responding to particular areas of focus, particular areas of increased risk. So certainly from my perspective, from a reg change perspective, we are very focused on looking at these changing requirements like the risk management program rules, which are, as far as I'm aware, still in that consultation phase. And we're really looking at seeing where that goes to when those rules are finalized, to see what entities are captured and what is going to be expected from them from a risk management perspective. So we can expect that to continuously evolve, how risk management is treated, what it means to be an operationally resilient business or asset, and how to report to regulators effectively, and what that means for when different compliance requirements express things differently and expect different things.
Well, that's a really good point, because I think it's one thing to understand what the regulations are, but obviously there are reporting requirements that fall out of this. So in your understanding, what are the obligations in that particular regard?
So to be really specific, you've got reporting obligations if you're a responsible entity for a critical infrastructure asset under that expansive definition of those classes we've already touched upon. Now that reporting requirement is 12 hours of becoming aware of a critical cybersecurity incident, and then 72 hours for other kinds of cybersecurity incidents. And among other things, an entity needs to report specific details about the incident, such as how did it come to light, how was it discovered, what was the type of incident, and what kind of technology or data does it impact. Now, what the legislation treats as a cybersecurity incident is specifically defined, but it essentially boils down to some kind of unauthorized access or impairment of computer data or programs. And then you've, of course, got the critical incident itself, which is a significant impact on asset availability, meaning an impact which materially disrupts availability of essential goods and services. There's another concept. What is an essential goods and service? And that's not really defined, but you really need to engage that risk management approach again. What disruptions could cause the most impact to an asset or those people that rely upon that asset? Then that's that first category. Then you've got that other category, which is the report needs to come after becoming aware that an incident has had, is having, or is likely to have a relevant impact. And that sounds very broad, and it is, and it covers covers an impact on availability, integrity, reliability, or confidentiality of a particular asset. So what we really see is that unpredictable and fast-paced nature of cybersecurity incidents, and combined with these very short reporting timeframes under legislation, they're quite short, and you don't have very long to respond once you actually become aware of something. It means that if you're a responsible entity, then you really must have a plan to report a cyber incident, well, before it occurs or as soon after it occurs. And if you don't, then there's a financial penalty for every single breach that happens. And you really need to make sure you're across the current penalty unit value, because at the start of this year, it's actually gone up. So once you start to build those things together under the legislation, that amount really can start to add up if you're found to have done something wrong.
That's right. I think it's gone up significantly, something like $50 a penalty unit.
Something like that. I don't have a calculator in front of me, but absolutely, it's gone up by quite a bit.
So Dudley, that begs the question. I mean, given the broad scope of what constitutes a reportable incident, how complex is this going to be for organizations to manage? Is there a default framework in place? Do people know who they actually need to report to, and does that vary depending on the nature of the incident?
Well, I think some do and some don't. I mean, I think Kieran has highlighted the absolute complexity around the reporting requirement, and I think that it's one thing for the requirement to have a to-do list of requirements that need to be ticked off when making that report. It's quite another thing to have access to that information at the time of a cybersecurity incident, to be able to pull that information together in an efficient way and to notify within that time frame. So it's the time frame that's really the challenge here. I think we're typically dealing with very sophisticated organisations that are used to being able to pull data from different sources, but that's not something that can occur in a very short period of time. And the reality of having to make a report within 12 hours is hugely significant for those that are managing critical assets. Not to mention the slightly longer time notification period at 72 hours. And I think some of the organisations that are now within scope, those that are subject to CPS230 in the financial services sector, insurers, super funds, they are used to complying with or having to comply with the 72-hour notification requirement. So perhaps that there's a level of comfort there, perhaps. But I think this new 12-hour notification obligation is a huge challenge. We did perhaps as a comparison to what we've seen overseas. When the GDPR was introduced several years ago now for the EU. That imposed a 72-hour notification obligation, and the reality was that those notifications that made that 72-hour requirement were pretty thin. They came through to regulators and supervisory authorities in the EU to say, hey, yes, we've had Houston, we have a problem. We're not really sure what's happened, but we're notifying you to tick that box, and we'll come back to you with further information. So to your question, I think the reality will be that whilst no regulator wants to see this obligation as a ticker box exercise, I think that 12-hour will put a lot of pressure on organisations to just notify and then say, look, we need to come back to you because we really don't know what's occurred and the extent of the breach at this instance. So long-winded answer to your question, but I think it's the timeframes for me that are the particular complexity around this reporting.
Yeah, and I guess that's a really good point, because on the one hand, reporting in and of itself is a good thing, but I guess there has to be some qualitative data behind that quantitative data in order for the regulators to form a view about not just what's happening today within a particular organisation, but to try and extrapolate whether there are particular trends in relation to potentially cyber attacks on a given industry or a given sector.
Yeah.
So with the increasing incidence of these sorts of high-profile cybersecurity incidents, and obviously last year we had a couple of very high-profile incidents, and as we saw in some of the fallout from that, other organisations put their hand up and said that they'd been implicated as well in similar sorts of incidents. Going over and above the reporting framework that's caught here, how else should organisations be reporting what's happened? Do you think there's public interest in play as well?
Oh, look, I definitely think there's a public interest in play, and you'll see with, and we'll talk about this shortly, but the privacy reforms that are foreshadowed very much sort of come back to that open and transparent approach that the Commissioner is wanting to see, and we saw that discussed in the context of the recent Optus and Medibank breaches, amongst other things. I think in terms of how organisations should be looking to report and to manage these at times competing reporting obligations is really understanding the baseline for their particular organisation and perhaps more helpfully for their broader industry. There are competing timeframes. There are different obligations under the Privacy Act for notifying of eligible data breaches, and the very loose rule of thumb is that you've got 30 days to make inquiries and then notify as soon as you form the view that a breach has occurred. Obviously, that's a very different notification time frame to what we're talking about here with respect to the SOCI Act and critical assets. So again, if you're an organisation that's subject to competing timeframes and competing regulatory obligations, having a very good understanding of where you sit and having your ducks in a row in terms of when those those reporting obligations are triggered, I think is a critical first step, so that you can build across those different compliance obligations a process that allows you to meet all of them at the relevant points in time once you've correctly categorised and identified the particular risk. Because again, by way of practical example, a privacy breach, which constitutes an eligible data breach, may not have anything cybersecurity related. It may be a pure personal information issue, and may not trigger other notification obligations. So I think two things, being across your broad reporting obligations across those various regimes is important, but also being to correctly categorise the particular incident and understanding, which reporting obligation it triggers is probably the next step.
Yeah, I think that's right. And having, oh, sorry, go on.
I was going just to piggyback on what Donnelly was saying there. I guess one of the other things to consider is, from a reputational perspective, particularly even your employees, if they're aware that you've had a breach and you haven't reported it to the customers or the public yet, if you don't do it yourself, sometimes you might end up with your employees leaking that information. So I think it's just another consideration. Yes, you have to weave that into all of the regulatory obligations that you have, and protecting legal privilege and things like that. But really consider what that reputation is. And I think ultimately that needs to be exercised. If you don't have an idea, or your management team don't have an idea about what they're going to do ahead of time, then that could be problematic. During an incident where people are tripping over themselves to some report or not report, or not having an awareness of what's our internal policy around that.
Yeah, look, and just to pick up on that, and Michael, I don't want to cut across your next question, but you've identified a very good issue that some organisations address very well, and that's that broader sort of culture of transparency and openness. So, there are organisations that they understand that they have a get out of jail card for privacy breaches as it relates to employee information, and they exercise that right. They choose not to notify employees, which from a good corporate citizen perspective doesn't leave a really good taste in the mouth if you're an employee of that organisation. So certainly we encourage organisations to take a more open and transparent approach. Obviously being careful to manage risk appropriately, but cutting their employees out of the loop because you fall within an employee records exemption is not. Yes, it might be legal, but is it good corporate citizen practice? Absolutely not. And being able to sort of capture how you're going to go about notifying in an incident response plan, testing that and regularly and making sure that it works is a really good way of being able to respond quickly and deal with that reputation issue that you've mentioned, Michael.
Yeah, look, and I think the point that I was going to make was it's not necessarily enough to know what your obligations are or have a response plan in place, but obviously the policies and procedures that are derived from those obligations need to be communicated across the organisation, and there need to be supporting training regimes in place so that in the event there is, for example, an incident and you have a certain period of time in which to respond, the whole organisation is alive to the fact that you are actually meeting your obligations, and somebody won't assume that because they can't see something's happening, nothing's happening, even though it might very well be happening in the background. And that again speaks to promulgating a good corporate culture where people within the organisation have a thorough understanding of what good corporate practice looks like and trust the management that they work with, that they will undertake to follow good corporate practice.
Yeah.
But that then turns to the instance of risk. So there are 4 domains currently in place. Michael, would you be kind enough to explain maybe what those domains might be, what they mean for the broader community that's potentially affected by the new SOCI Act, and the extent to which risk management plays a part in all of this?
Sure. So as you said, there are 4 domains, but if I take a step back for a minute, and they define material risk in these risk management rules, while there's more specific obligations, they come down to sort of 3 key areas. So one is continuity. Can you continue the performance or availability of that asset? And probably more importantly, the services that it provides to the community. Do you have control of it? So maybe there's no disruption, but if you've lost control, for example, lost physical asset, you no longer have access to it. Essentially, that means you can't guarantee the continued performance. And then your data, so data related to that critical asset and the ongoing performance of that critical asset. One thing that I find interesting about the definition in the rules of material risk is the focus on impact. So it's the impact on these things. It doesn't really mention likelihood, which is something that's quite common. Likelihood and consequence, or likelihood and impact, is often terminology that risk professionals will use when they're looking to measure risk. The rules don't really consider that. They're looking for any risks that have this kind of impact, which is a lot more aligned with an operational resilience approach, and making sure that you're ready for any type of disruption. So those 4 domains that are captured are the cyber, which we've covered off a little bit already. Personnel, so making sure that you've got security checks in place, things like insider threats that you're effectively managing. The supply chain, so your third-party providers or people servicing your assets, how well are you managing the risks related to those? And then the physical and natural hazards. So the physical locations of your assets, so it could be actual threats. So, if we think about terrorism as an example, but it can also be those geophysical natural threats. Australia is quite prone to, over the last few years in particular, bushfires, floods, etc., which could result in some of these, disruptions to your critical assets or the unavailability of your critical asset. I think while they've got these 4 domains that they've defined, for these risk management rules, and absolutely they're all relevant, they're not really in a silo. There's a lot of interconnectivity between these risks, and I think if you think about the causal chain of any individual, risk event or incident, it may cross lots of these boundaries. So if I think, if we look at, say, cyber and personnel as an example, if you don't have good vetting processes and you let an insider threat into your organization, and you also don't have strong cybersecurity controls, that insider threat, we may have, be there for cyber espionage, can now, affect your critical asset. And there's the same for any of those domains. There'll be a crossover in a lot of those. Supply chain and cyber is the same. If you've got systems that are talking to third-party supply systems, that could be another way that a cyber threat will potentially get into your, into your organization and threaten, the performance of your critical assets.
Yeah, thank you. So going on from that, in terms of what we've just had a look at through the lens of enterprise risk management, how do the requirements flowing from SOCI align with proper enterprise risk management procedures?
Yeah, so if I think about, I guess, taking a step back on what enterprise risk management is at a high level, it's really understanding what are the objectives to your organization and what are the risks or threats that will prevent you from achieving your objectives. Now, some of those objectives are going to be related to your critical assets. Some of them will be just about your performance, your growth of your organization. So the 4 domains really are just a part of that whole enterprise risk management journey. And I think if you don't have a strong risk management program in place already, and these rules are making you sit up and think about it, if you just pick up the 4 domains of SOCI, you're probably leaving something on the table, and you're probably thinking about what does this look like at an enterprise risk management level. So it's not just that preventive, responsive or reactive element. You're actually looking at where do we want our organization to go, what are the objectives of the whole organization, and how do we manage risk to all of those objectives, critical assets or otherwise.
Yeah, fair enough. All right, thank you. Look, if we've now sort of defined terms and we've looked at sort of where things are, the current regime is playing into kind of existing structures and so on that people might be familiar with, I guess that the next thing to turn to is what comes next. So I'd like to invite the panel to maybe share what they think will flow next from the nation's parliaments, and perhaps what might be informing that, perhaps from experience overseas. So, Dudley, I'd like to turn to you first. For the last 5 years or so, there have been some significant legislative reform, and not just in this space, but more broadly, we've seen some extraordinary changes in a variety of different industries. But maybe if we were to look at privacy reform, where have we seen that to date, and what do you see as the significant sort of landmark legislative amendments that we'll see in 2023, perhaps in 2024?
Yeah, look, it's a big question, isn't it?
It is, I'm afraid.
That's okay. Look, the last 5 years, I guess, have seen a flurry of activity from a privacy reform perspective. So if we cast our mind back to 2018, we saw the introduction then of the notifiable data breach scheme under the Privacy Act, and that was really the first major reform to the Privacy Act since we'd seen the introduction of the Australian privacy principles back in 2014. So there's a bit of a gap between that 2014 and 2018 period. But now that particularly since the change of government, we've seen that really ramp up. So in 2020, the then government sought some input and submissions in relation to proposed privacy reform. That's moved forward from that initial issues request through to a consultation in 2021 to the more recent final report that's just come out from the Attorney General on the 16th. So that huge document at 350 pages is open for consultation for the next 6 weeks or so until the end of March, and it already contains a number of recommendations, and a lot of those recommendations pick up on what we'd anticipated was part of that reform agenda. So things like a tort of privacy for privacy breach, the right to be forgotten, all of these sort of terms that have been bandied around and what we have been aware of from an overseas perspective as being in place in the EU and in the UK Data Protection Act and the GDPR equivalent. What does that mean from now on? Well, we saw the introduction of civil penalties in the back end of December last year, just as we're all about to go on Christmas holiday, and the 13th of December pushed through fairly significant reforms to the Privacy Act, increased the power of the Information Commissioner, encouraged a broader set of cooperation between government agencies, which we saw play out in that Medibank and Optus breach events. But most importantly, from a I guess, a risk perspective is that we've really seen the toothless tiger of the OAIC given a fairly sharp set of teeth with those newfound powers to seek penalties in the vicinity of $50 million per breach. So that's a move up from $2.2 million for a corporate, right up to $50 million, and there's a relatively complex process that you will go through to establish where you end up there. That's significant. That's a big risk for organisations to take on to begin with as they go into 2023. Now with that final privacy report coming through and the recommendations attaching to it, we're expecting to see a raft of agenda coming through in the back end of this year in Q3, possibly into Q4, which really increases the compliance burden on organisations. And the larger organisations, they're prepared for it, or at least some of them are prepared for it. But some of those exemptions, like the employee records exemption, the small business exemption, are likely to fall away, and that is really going to turn the screws on those smaller businesses that have enjoyed a less rigorous compliance obligation, some falling out of scope altogether of the Privacy Act. Sorry, long-winded answer to your question. I think 2023 is going to be a huge year from a privacy perspective, and we're only scratching the surface now and getting to grips with what that's going to look like moving forward for organisations.
Yeah, exciting times. Interesting that fine that you talk about, $50 million, that aligns fairly closely with the penalty that flows out of breaching GDPR. So interesting that potentially that's the model that they're looking to build on. Kieran, I mean, you're at the coalface of change on a regular basis. More broadly, going beyond privacy, what are the other significant changes that you've seen maybe in the last 5 years? And where do you see those other landmark changes potentially progressing on this year and next? Because obviously privacy, as Dudley pointed out, there's a significant likelihood of significant reform coming down between now and Christmas.
If Dudley's question was broad, I think that one, if I really wanted to dig into it, if you left me off mute for long enough, I could just talk for maybe a week. But look, it really, and particularly since it may depend upon those of you that are on the call are going to be thinking about different things that are relevant to your industry. You'd be thinking, and depending upon where you happen to be. So if you're a Western Australian business, you'd be very focused on the workplace safety changes that have just come through. If you're a heavy vehicle operator, you've certainly needed to make changes in response to SOCI, but then you're also probably thinking quite heavily about what's going to come out of the review of the heavy vehicle national law. So it really does depend upon what is the nature of your business and what kinds of activities you engage in, what products do you sell. And as you start to engage with that, the breadth of regulatory change starts to become apparent, and the complexity of that change starts to become apparent. And particularly if you have overseas supply chains, if you have data that is going overseas, which you probably do, even if you don't think you do. And it's really when you start to think about that complexity of what is the regulatory regime that you as an organization need to tap into. So you start to realize that there's these multiple disparate pieces of legislation across multiple different areas, across Australia, states and territories, and then overseas, that all feed into what your compliance framework actually looks like. And you may have hundreds upon hundreds of instruments that you need to keep on top of in the sense that they are changing very, very rapidly. And certainly we can see that in Australia with the reform cadence of, well, particularly now the current government and what they're looking to do in the year ahead. And if you start to, I guess, look at a regulatory change and follow it through the organization from an operational compliance perspective, if you take something like design and distribution obligations in financial services, as you work through the workflow of trying to implement something like that, it bounces around the organization and so many different teams need to contribute to it. So things are happening faster and faster. It's more complex aligned with that, and then as an organization, you then had to pick out these priority things that we've talked about some of them already. If you look at financial services, which is still where the bulk of the change is focusing on in the wake of the Royal Commission, you've got things like the financial accountability regime, and then you've got recent changes like unfair contract terms, the respect at work changes. The list really does go on, and as we've said, you can't really escape it outside of financial services, because there's a change backlog and a change log looking ahead that really does impact on industries everywhere. So not going beyond SOCI and the operational resilience piece, you really need to be thinking about what is the breadth of that legislative landscape that you are tapping into, and then, as Dudley's already indicated, looking at that change horizon for things that, as an organisation of any kind of size or any kind of background, you've got that cyber and privacy regime change that's very much on the horizon.
Yeah, no, sorry, that was quite unfair to you both. They were very broad questions, and given we don't have a week, we only have an hour. Thank you both for dealing with those questions in a concise and comprehensive way. Look, I guess in a way we've touched on it already, that there are elements of reform that in the Australian jurisdiction at least have been informed by movements started overseas, and obviously GDPR is the obvious example when it comes to privacy, and there are other things that we're seeing, for example, with ESG reform that seems to be sort of touching Australia as well. So, Dudley, you've already touched on what you see sort of coming down the line here, but would either of you, and I'll start with you, Dudley, to the extent that you've seen changes overseas that have touched on the way that Australia is reinterpreting its corporate obligations in this space, where have you seen similarities between what's happened and what may be happening here that might give organisations some guidance as to how to respond to future change?
Look, that's a difficult question. I think the Commonwealth has always found it somewhat frustrating, and again, talking from a privacy and data protection perspective, that they've always felt, and again, I'm putting words in their mouth in some ways, but there seems to have been an ongoing frustration when looking overseas that, notwithstanding the criticisms of the EU General Data Protection Regulation, in some ways, it did some things very well. So it really played to that consumer requirement around individual rights, which are so important for European citizens and legislators. So the changes that flowed through from that, the right to be forgotten, the rights of erasure, that they're all now very much sort of firmly on the reform agenda here in Australia. And I think the other frustration from a Commonwealth perspective is that while certain other jurisdictions were recognised for equivalence from a privacy perspective, including our closest neighbour in New Zealand, Australia is with its approach to allowing exceptions under the Privacy Act, particularly the small business exception and the employee records exception, was enough to sort of keep it out of that tent. And I think, given where we are now from a global perspective and an information sharing perspective, I think the Australian government was wanting to be back in that tent and being able to sort of share information broadly and have the same sorts of benefits that nations being able to transfer and disclose information to the EU, to the US, to the UK in an efficient way that countries such as New Zealand and others have had. It really wanted to be back within that tent. And so we're seeing that coming through now with the reform agenda. We've also perhaps seen some other initiatives from an Australian perspective that are a little bit different. So the introduction of the consumer data right, rolled out first the financial services sector and now being implemented in energy and soon to be implemented in telecommunications, was a real nod to where the government wants to be in terms of being consumer focused, in terms of allowing consumers to direct how organisations use their data, how they disclose their data, how they manage and how they engage with consumers more broadly. So that legislation is particularly interesting, and not that Angeline Falk doesn't have enough to do with the privacy reforms, but she's very much focused also on seeing the successful implementation of the consumer data right across those industries, and then again more broadly once it's rolled out. And that's, you know, that's a pretty ambitious task, and certainly adds to what Kieran was saying before, which is, you know, if you weren't sort of already tied up working out how to comply with the privacy reforms, you've got a huge raft of other legislative requirements that may impinge directly on your industry. So there's, you know, if you don't have regulatory compliance people in-house and you're not leaning on your providers to assist with that, then you're probably all at sea, I suggest.
Yeah, and that's an interesting thing, is that as more and more legislative reform flows out of the nation's parliaments, I think the point that you were making before is that there are, you know, in the what we talked about before in terms of cybersecurity and privacy, parallel but potentially occasionally touching instances where reporting the same incident might need to be reported a couple of times, or where you might get, in certain instances, not just complementary, potentially contradictory requirements. But it'll be interesting to see whether over time, as the new legislation takes effect and people become familiar with it, whether there'll be elements that might need to be harmonized, you know, similar to the way that we've looked at work health and safety recently. So Kieran, turning to you, again, look, moving beyond sort of privacy and cybersecurity, the other changes that we discussed earlier, do you see the government looking to what's happening in other jurisdictions and trying to take the beneficial elements of those and maybe walk past some of the elements that didn't work so well as part of their broader legislative reform agenda?
I think that definitely, looking at the experiences in other countries, you can see trends towards regulating particular areas and focusing on particular risk areas more. And sometimes Australia's, you know, quite behind the 8 ball in responding to things. And sometimes, if you look at the landscape, it looks like that we may be further ahead in certain areas. And certainly it kind of shifts between, I guess, the focus of the government of the day, and that's across many different countries. If we look at, say, the US and UK, you can see, and let's look at it from a critical infrastructure perspective first. You can see similar themes in terms of this recognition that, yes, critical assets need to be managed effectively, in terms of how organizations are responding to these kinds of cybersecurity risks. And so you've got the UK putting in something similar to SOCI with its network and information systems regs in that 2018 period, so not too long after we did, but very clearly they're still behind in terms of the essential services that they're picking up, because while their list is not just narrowed to that utilities piece, it's not that much wider. So certainly there's a bit of catching up to do over there. But then you've also got that similar reporting obligation of 72 hours. So we've just kind of caught up to that. So there's little pieces where they're behind. There's things where we're catching up in terms of different elements of legislation. You can see this trend towards ideas. And again, as Dudley's already pointed out, they all kind of link together by looking at key themes around things like GDPR, where those reporting timeframes come from. So with GDPR, for example, while it's still regarded as the gold standard, the question will then become, well, as the GDPR evolves, and certainly there are some hints that it may itself undergo a review, what the broader flow-on implications of that will be to other countries and to Australia in particular. If we look at the US, for example, and I can't imagine how everything kind of fits together with the states, with the complexity of the legislative regime that they're trying to manage there, but certainly from a privacy perspective, they've got multiple different states that some of them follow GDPR, some of them don't. They're playing catch up. I think there's a lot of states that are starting to implement legislation that is quite similar to GDPR, and I think that's the Californian model of the legislation. But they've also got their own critical infrastructure Act, which has that 72-hour time frame, which focuses on that reporting of jeopardizing information systems, etc. So we can see similar themes. If we look at operational resilience, for example, then we see similar trends as well. Maybe not so much in the US, but definitely in the UK, where they've got where last year they had a new operational resilience regime that took effect, which was very much introducing requirements for banks and insurers to make sure that the sector itself is overall operationally resilient, and again to really hone in on that consumer protection piece across the financial services sector. So to really boil it down, I think that there's things we can learn from the global landscape, and we can certainly see themes that are being shared across jurisdictions, picking them up from different regulatory requirements. But the problem then becomes, as you've already pointed out, when those requirements are shared but they don't overlap, then you actually create conflicting and potentially overlapping requirements rather than shared requirements that may be able to cut across different regulatory areas like reporting, for example.
Yeah, no, thank you. Look, to pick a particular case in point, and just riding off the comment that you made before about what the FMA did in the UK, Michael, I'd like to turn to you now and look at what the FMA did, and maybe have a look at, consider what's coming in the form of the CPS230, and maybe explain for the benefit of those people listening who aren't familiar with the idea of the Common Prudential Standard, what CPS230 might do. And then maybe have a look at the distinction between maybe the compliance-based approach versus a risk-based approach.
Yeah, certainly can. And CPS 230 is the operational risk management standard for financial services in Australia. It's issued by APRA, the Australian Prudential Regulation Authority. It's currently in draft form, but I wouldn't expect it to change a lot. But it really closely models that UK model of caring about the customer and mapping all of the resources that relate to the services that you're providing to that customer. And if we go back to, I guess, linking it back to critical infrastructure, I think it's a lot of the same. And going back to what Dudley said, it's knowing what the impact is your critical infrastructure also has to your customer. So I think it's the right model. And I almost think in some ways we've missed the mark a little bit with the risk management rules and being focused on critical assets as opposed to being focused on the services that those assets deliver. I think because the risk management rules have to cut across, a range of sectors, probably needs to be that way. But I think ultimately I would expect in future we might see some finessing of those rules related more to the outcomes to customers and communities as opposed to just specifically about the asset.
Yeah, thank you. And I think there's a really important point here, and I think the way that APRA approaches it makes a lot of sense because, well, CPS 230 talks about operational risk management. The other limb to that, CPS 234, information security, taken as a whole, APRA sees as the obligations around that broader concept of operational resilience. So Dudley, I'd like to turn to you for a moment and look at how critical infrastructure and operational risk management and cybersecurity reform work together to create an environment where organizations can be a little bit more resilient and certainly alive to not only the risks they face, but the proper response to those risks.
Yeah, look, I think that's a really good point. And perhaps if I take that question from the perspective of how does all that link together effectively, and perhaps looking at it, what is an ineffective or poor approach, and that's an approach that sees risk compliance dealt with in a vacuum, focusing on a particular requirement, focusing on CPS 234 or the requirements under SOCI or the whatever it is that is the making the most noise. And that siloed approach to risk compliance is a very risky strategy, and we see those organisations that approach it on that siloed basis, and it's often just evolved over time without any sort of perhaps the organisation in some ways is a rudderless ship and it's just happened over a period that's how it's ended up. The organisations that are able to sort of step away from that detail, perhaps taking that helicopter view more broadly around risk, they start to open up those silos. They start to make the linkages more broadly across the business, and are able to put in place more effective process and procedure around compliance. So they look to the broader reporting obligations, and they're able to tie together or bring together the various competing reporting obligations that might apply to that business or to that industry, and they're able to do that by seeing those linkages, and that allows them to do it more effectively. So I guess to your question, how is it all linked? I think recognizing that it's all linked is perhaps the first and most important step in terms of an approach, a sensible and strategic approach to risk, and understanding that there are linkages, and that to sort of get caught too much in the weeds and focused on a particular compliance requirement is a recipe for disaster in some ways, and you need to have that helicopter view broadly across the organisation in order to manage it, to manage all of those risks effectively.
Yeah, thank you. That was my question. I'm going to throw to Michael here. In the event that your organisation has adopted an organic approach to operational resilience, and you wanted to reset, what are the key principles of operational resilience that an organisation would need to consider? And maybe consider those key principles in the context of, maybe we'll start with critical infrastructure and move out from there. What are the key principles that you see as an organisation would need to look to when they're beginning to either start from greenfields or begin to rebuild the structures that have happened to evolve over time?
Sure. So if we start with those principles, and I guess one of the comparisons often made is around business continuity, and I see business continuity as often a quite responsive or reactive approach. We have had a disruption, and how do we get back to where we were? Where operational resilience encapsulates that whole life cycle of disruption. So how do we prevent it from happening in the first place? How do we make sure that we've got the right measures in place, whether that's monitoring key risk indicators to identify incidents that are coming and in progress, so you're learning to adapt and absorb to that impact. And then still leading into those traditional focuses on recovery and how do we then learn and adapt, because I think it's about not just coming back to where you were, but coming back stronger. And if I lean into the CPS 230 requirements, one of those, I'm interested to see how this actually plays out from a regulation perspective, is they're expecting organisations or the financial sector to set for some of their critical services a minimum level of service during disruption. I'm quite interested to see how that actually plays out in practice. So it's not just about how do we recover, but how do we still deliver some of our services while we are disrupted, which I think is quite an interesting change in our operational resilience approach. So think about that whole life cycle of disruption. How are you potentially managing that and making sure that you've got those outcomes on a continual basis, even during disruption?
In terms of sorry. Oh, sorry, you go.
I was just going to go to the second part of your question, but yeah, I'm keen to hear what you've got to say.
I was just going to say, in terms of looking at the way that people will identify the risks and begin to apply those principles in practice, obviously there'll be role playing, there'll be pre-mortems, there'll be a bunch of techniques that they can begin to perhaps identify vulnerabilities either within the organization, be it cybersecurity risks, be it supply chain risks, and be able to put in redundancy or some sort of sense of I guess resilience is the key term to keep that critical infrastructure going. But applying those principles to critical infrastructure is of course what we're talking about today. How do you see organizations in practical terms building operational resilience into the broader SOCI landscape?
I think the first step is to really understand your critical asset and how it operates. So what are the services that you provide, and why are they important? And then what are all the key processes? And if we lean into CPS 230, for example, it requires a mapping of the resources, the people, linking to your compliance obligations, any of the controls you have in place to make sure that the components and the resources required are in place. So I think that's one of the key principles. I think is really getting that understanding of your asset, how it operates. As you said, identifying those vulnerabilities in the individual pieces. So rather than just thinking about it as a whole, and which is hard to sort of conceptualize, is to really break it down and say what has to happen in what order to get this this outcome, for our communities, for our external stakeholders. Where are we vulnerable? As you said about the pre-mortems, running scenarios to go in this particular scenario, which bits of our components will be affected and therefore would lead to a poor outcome. I think that's the way I would be approaching the operational resilience.
Yeah, and I think, okay, and I was thinking one of the other benefits of taking that approach would be, even within organizations that have a reasonable level of maturity, there'll be aspects inevitably of any organization that have different appreciations for risk, perhaps inconsistent approaches or inconsistent understandings of the regime under which they operate within that organization. And this might potentially give the organization a holistic view as to where their various risk maturities might lie across the organization. Would you agree?
Yeah, absolutely.
Yeah,
I think nailed on the head. I don't have much to add to that.
Yeah, brilliant. Sometimes a simple yes is all we need. All right. Well, look, this segues neatly into our product showcase featuring LexisNexis regulatory compliance content in the Protecht workflow solution that will help organizations, both I think people have joined us today, and more broadly, help monitor the regulatory change landscape so that you can understand, implement, and then report on those compliance obligations that you have. But before we do, what I'd like to do is turn to our three panelists today. Perhaps even before that, to say thank you all for your time and your wisdom and your insight. I've learned a great deal, and I hope people on the call have done too. But we might first turn to Dudley and just ask you, are there any other issues that perhaps touch on what we've looked at today, but we haven't thoroughly ventilated?
Look, I think we've ventilated and touched on quite a lot. I have a special place in my heart at the moment for the consumer data right, as a very new piece of legislation which is rolling across. As I mentioned, it's come through banking. It's rolling across the energy sector at the moment, and we're working with a number of clients to help, really to help get them up to speed with what that looks like. The challenge of that piece of legislation, and I think we'll start to see it more so with other bits or other pieces of legislation as well over 23 and beyond, is that there are lots of cooks in the kitchen. There are lots of regulators that are working pretty closely together. The ACCC's now working very closely with the OAIC. ASIC and APRA, perhaps not best friends, but certainly, again, working closely together. So that genuine, regulator cooperation, both at a domestic Australian level and it's also overseas, is a huge advantage if it's been done effectively certainly from a regulator perspective, and gives them enormous advantage to roll out complex legislation across the industry. So that's sort of allowing the government to attack what's a pretty ambitious reform agenda in 2023. So that's what I'm interested in seeing play out over the course of 23. We didn't really touch on that agency cooperation piece today, and certainly that's something that we can visit in later sessions. But I'm pretty keen to see how that plays out, and I think that'll prove a challenge for industry, and it'll be those industries that are able to respond at an industry level in a coordinated fashion that will be able to sort of successfully take on and consult with government, who's putting themselves in a very good position to roll out complex legislation that they feel is important.
Yeah, I think that's a good point, and certainly that intra-regulator and inter-regulator cooperation, I think, bodes well for future legislation, because you're quite right. There are always aspects of overlap and collaboration that may not have been thoroughly explored previously, but I think that we'll end up getting better law out of that cooperative approach, which I think, yeah, bodes well for the future. Michael, is there anything that you'd like to share with us before we turn to the demonstration?
Well, I think we did touch on it earlier, but just around that supplier management, third-party management, vendor management process, that I think that is going to play a much bigger part. And if we think about financial services, this is already happening, but I think it will definitely flow into these other critical infrastructure sectors, is that financial service providers who have the obligations placed directly on them often push some of those obligations out, or audit requirements and assurance requirements on a contractual basis to their vendors. And I think we'll see that happen more and more in critical infrastructure as well. And I think particularly you've got people who are critical infrastructure asset providers themselves or owners themselves, who will also be perhaps providing services to other critical infrastructure providers. So I just think that's an interesting kind of dynamic that's going to probably play out over the next few years.
Yeah, look, I think if there's one thing that we've seen in the last couple of years is that there was an unspoken but clearly crucial reliance on a global supply chain in order to provide us with the goods and services we've just come to expect. And those dislocations we've seen over the last few years, I think, have thrown the fragility of that global supply chain into account. So maybe when we're talking about third-party suppliers, maybe we'll look at something like the modern slavery approach, where we'll have tiers of critical infrastructure and tiers of third-party assurance that we'll know that to the 10th tier that everything that we need and everything that we expect of our suppliers is capable of being supported, even just beyond that initial relationship. Finally, Kieran, is there anything that you'd like to share or discuss further that we may have only touched on briefly today?
I feel like the anchor in a debate team where you end up with all of these amazing ideas that come down the line and you go, I just want to echo all of that and pick up bits and pieces that we've already discussed. So, look, I wouldn't add anything in particular on top of, I guess, even like the whole discussion and in particular these additional insights at the end. I definitely think that looking at the cross-regulator cooperation, certainly that was an observation that we've had, particularly in the last 12 to 18 months, where when we are sending out notifications to our customers, we're seeing this increased incidence of, oh, these financial regulators in Hong Kong and Australia and that are working together on this agenda item or this focus area, and seeing those, even if it's just a media release that they're working together, seeing that increased incidence of these entities starting to work together. And that, of course, is at that higher level to the Australian context, where particularly for a financial services provider, you see that cooperation between ASIC and APRA. And I love the analogy of getting in the helicopter view. And certainly as you implement a really robust compliance and risk management program, you need to be in that helicopter and really looking at what's happening across the organization. And particularly if you look at it from a horizon scanning perspective, you can see that horizon when you are up in that helicopter. The analogy that I often use in my day-to-day is that you have to be in a helicopter and on a bungee cord, because you need to be able to jump out if a regulatory expectation is getting so specific, so granular, that you really actually sometimes need to be forced into the weeds to think about how am I actually aligning this framework together. Breach reporting is a fantastic example of that, where even the regulator is recognizing that, yes, we need to simplify this, we need to make this easier to implement. And if we look at the way the APRA is looking to modernize its prudential architecture, it's this clear recognition that granularity of regulatory expectation is making it challenging in terms of getting out of the weeds and staying in that helicopter and making sure that you have that proactive view looking across the organization. And I would then also echo the point about the looking beyond what is your regulator and thinking about who is the regulator of the entities I do business with, and thinking about from a contractor or a subcontractor perspective, who I might actually be complying with, because these requirements are flowing down to me through the processes and the policies that are being placed upon me by the entities that I do business with. And I think that certainly in terms of implementing your compliance journey, I think that these are certainly going to be challenges and interesting processes to monitor heading into the rest of this year and the years ahead. And I would certainly encourage those that are on the call to, as much as possible, try to take that broad reg change view across what is actually coming up and staying in that helicopter as much as possible, and to see, really what might be coming next in Australia and looking internationally. And as you continue down that path, we'd love to hear from you and to make regulatory compliance part of your journey. And hopefully, looking at the demonstration that's coming up, you can see that real shared solution that may be possible.
Brilliant. Thank you, Kieran. Thank you all for your time and your attention today. I hope it's been a useful and informative experience. Now I'd like to turn to Michael Howell, who through the Protecht system will have a look at the operational resilience module they've developed. Michael?
Yes, thanks, Michael. As I said, I've spoken a lot about mapping today, and I think a picture tells 1,000 words. So here is an example of delivery of electricity to customers using our operational resilience mapping tool. Just to give you a very quick walkthrough, it is a very simplified example, but we can start with the production of electricity at the power plant, moving through the transmission through some substations, ending up finally being delivered to the customer. Now, what we can see in this process map is we've built some redundancy, such as, for example, if transmission line 1 is down, transmission line 2 will still be able to deliver that electricity to the customer. And for each of these resources, we can start mapping all the data that sits behind them. So how vulnerable that particular asset is or that resource is, how critical it is. You can map your business continuity plans to them if there is one that sits behind that, and making sure that you've got all of those assets in place to deliver that final view. So this is really about making sure that you've got that full understanding of how your assets deliver the value to your communities or to your customers, to then really understand how you can map scenarios to that to find out how many would potentially be disrupted. And you can have as many maps as you like, which means that you can run your scenarios against a particular resource that might appear in many maps and understand the overall aggregate exposure you have to particular scenarios that might come up in your risk assessments. So just give you a very high level view of that, and we'd be happy to hear from anyone who wants to have a more specific demonstration. Back to you, Michael.
Thank you, Michael. And with that, we'll wish you all a pleasant day. And as I mentioned before, look forward to seeing you all again soon at our next webinar, if not before.